Any mention?
Yes.
May I please your lordship? I beg to mention item number 9.
Yes.
Your lordship, the conducting counsel will not be present because he's having some personal difficulties, and we are praying for 2 weeks.
You are appearing on the respondent number. How many respondents are there?
7. We are from respondent 1 and 2.
1 and 2 is cantonment, rest are private respondents.
3 to 7, your lordship.
I have no objection, my lord.
Just one prayer made by Mr. Swanson, Lord Counsel appearing for the respondent number, not objected to by Mr. Ahmed, Lord Counsel for the petition. This is met after 2 weeks.
Yes, your much obliged, your lordship.
May I please, your lordship?
Yes.
Item 21, my lord. It's a criminal petition, my lord.
Yes.
I'm seeking further 2 weeks' time, my lord.
No objection.
The request of the petition after 2 weeks. Yes.
Highly obliged, my lord.
Lordship, I beg to mention item number 13, Lordship. Lordship, I pray that matter may come after 2 weeks, Lordship.
You are private respondent. Your Lordship, I'm appearing for the state.
No objection.
No objection, Your Lordship. You are for private
Yes.
respondent.
Same order. The request of the petition list after 2 weeks. Yes.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 22.
Yes.
I pray for 3 weeks' time, my lord, for hearing.
Lordship, I have no objections.
It's on request made on behalf of the appellant. List after 2 weeks. Yes.
Deeply obliged.
Please, lordship. Lordship, I beg to mention item number 10, your lordship.
Yes.
Your lordship. Pray for a week's accommodation, your lordship.
These are connected matter. 10 and
Your lordship, 10, 11 and 12.
No objections.
is also on request made on behalf of the petitioner, not objected to the law and GAP and for the state. This is met after 2 weeks.
Much obliged.
Lordship, I beg to mention item number 14 and 15, Your Lordship. 14 and 15
Yes.
for 2 weeks, Your Lordship.
No objection, Lordship.
Same order, 2 weeks, 40. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 18. I pray that this matter will come after 2 weeks. Lordship.
We have petition, Mr. President. Yes.
May I please, my lords? I beg to mention item number 23. Lordship. The conducting counsel, Mr. R. Gurung, has some personal difficulties.
Yes.
I pray for 2 weeks, my lord.
No.
Mr. Miss Chain Law Council. Appearing for the state respondents. Praise for adjournment of the matter by 2 weeks. Stop. Mr. Deb Lawnett Council appearing for the appellant has no objection. Prayer allowed. List after 2 weeks.
Grateful, Your Honor. Grateful.
Malta, I beg to mention item number 19. I'm for
Item
the
9.
respondent number 19. I'm for the respondent number 2. So conducting counsel, Mr. Espandi is not available today.
Lordship, in this matters, it's for the respondents to produce the authorities, Your Lordship. Since the authorities, the respondents have to produce the authorities from our side. In this case, that matters is whether section statements on the section 164.
Yes, yes.
Yeah. So till now they haven't produced any rulings.
Okay. Now what about his prayer today?
Malta will produce all the.
Then we're asking for an adjournment, isn't it?
Yes.
Yes.
I don't have any objection.
Do not have objection. Yes. 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 On prayer meet by Mr. You are appearing for respondent number?
2.
Okay. So Lawnett Council will be responsible. Common not objected to by the Lawnett Council of the petitioner. This is met after 2 weeks. Yes.
Thank you.
May I please, Your Lordship? I beg to make a mention of item number 6. Your Lordship, due to personal difficulty, my senior is not available today. Your Honor, if the matter may
Who
come
is
up...
your senior here?
A. Khan, Your Lordship.
Yes.
No objection.
Just say that is on request of the petitioner, not object to the respondent. List after 2 weeks. Yes.
Daily causes, item number 1.
May
Yes.
I please, Your Lordship? I need some more time to file the affidavit in opposition.
There is respondent number 5.
Accountant
Nobody's there?
general, no one is there.
Okay. Just say so and so appears for the petitioner. None appears for the respondent number 5. Then say on prayer made by MSS Better Journey. Another G appearing with us number 1, 2, 4. How much time you want?
2 weeks, Your Lordship.
2 weeks time is granted for filing opinion opposition.
Much obliged, Your Lordship.
Item number 2.
Yes.
May it please Your Lordship. Your Lordship, I'm praying for 3 weeks' time to file my affidavit in opposition.
Yes. Here for the respondent number?
1, 2, and 3, Your Lordship.
Yes. You will also file an affidavit?
Yes, Your Lordship.
Okay. Just say on prayer made by MS JD Notary, London GA, London Council appearing for the respondent number 1, 2, 3, and MS Pasa, London Council appearing for the respondent number 4. Further 2 weeks time is granted for filing affidavit in opposition in the matter.
Obliged, Your Lordship.
Yes.
Item number 3.
Yes.
Please, Your Lordship. I'm praying for some time, Your Lordship, to file my affidavit.
You also will. So just write the same order like this thing. You are appearing for Mr. Pala, you are appearing for the phone number 1 to 5.
1 to 5, Your Lordship.
And Ms. Pasa, you are for 6. So just same thing, just change the respondent. Yes, 2 weeks.
Yes, Lord. Obliged, Your Lordship.
Hearing, item number 4.
Yes. Yes, Mr. Karim.
Please, Your Lordship. Lordship, the GHDC is not presented, Your Lordship.
Oh, my friend is there.
Lordship, this is an in this application, Your Lordship, we are challenging the appointment of Nakuma of respondent. Four and 5, Your Lordship.
Yes.
Lordship, if I may take, Your Lordship, the annexure 1. Lordship, type copy will be at page 18, Your Lordship.
Page
18.
Mr. Deb, you are appearing for?
I appear for 4, 5, and 6, Lord.
Just private respondent. And district council is represented by?
But before that, Lordship, before my friend goes into the merit, Lordship is pleased to see the order passed by Your Lordship on 8th of April 2020. Should have been 25, it's written as 24 in the order. 8th April.
That's order sheet.
In the order sheet. 8th April 25. 8/4/25. Well, it's written as 24 on the top, but
in the order sheet. Very.
This is an order of 8/4/25.
Just a minute. Just a minute. Let us see. Yes, it should have been.
By an
See,
order.
this is something very. This has to be. This has to be taken serious note of.
Even in the e-signature, it is 24 at the next page.
This will be corrected in the order sheet.
It
It
can
has
be
to be
corrected
corrected.
today also that there was a mistake in the last order at date only. So, Your Lordship will kindly see the order. By order dated 28/3/25,
Yes.
last opportunity was granted to the petitioner to file an affidavit to controvert the assertion that the respondent 5 and 6, of the respondent 5 and 6, that the petitioner has no blood relation with the Nokma.
Yes.
So it was a question of locus, Lordship. However, no such affidavit has been filed by the petitioner till date. Then, counsel for the petitioner prays to grant some more time for filing the affidavit. Prayer has been vehemently opposed by learned counsel for respondent 1 to 3. It is further submitted the time for filing the affidavit had been granted since 23/8/2019. Taking into consideration the above aspect of the matter, and since last opportunity was granted, this court is not inclined to grant any further time. The opportunity granted earlier stands closed. And Lordship has placed the matter for hearing. So the position still remains as it was in 2019, that they have not established their very locus to.
Yes. How do you deal with that situation?
Lordship, we are the Maharis and Charas of the.
Then which way you have the locus standi?
Lordship, this Jinsang is Sangmai, Lordship.
You will correct the
Lord
speed
of
of this
Garula.
order. 8/4/2024 April.
Because this is a case where the mother has given to the daughter.
Now, this is this 28/3. Now, order of 28/3 was passed
By Honorable Chief Justice,
Yes.
granting last opportunity to controvert the, or to establish the locus, in other words, Lordship.
19th August 2019 is this things,
Is
isn't
the
it?
original order by which
Yes, this is 23rd August 2019, isn't it?
23rd August 2019.
Where is that? Let us just see what is there.
Lordship, that order is there. 23/8/2019, passed by the then Honorable Chief Justice. If I may read it, Lordship.
Just a minute. Just let us. Yes.
In the affidavit filed on behalf of respondents 5 and 6, locus standi of the petitioner to challenge the Nokmaship of respondent 5 and 6 has been laid. It is asserted that the petitioner has no blood relationship with the Nokma. Learned counsel prays time to controvert the said argument. So till today the controversy has not come. The fact remains that Lordship, that there is a challenge to his locus, which he has not, in a sense, controverted till date.
It should be the person who has a rightful
Lordship,
claim to the position.
Yes, how this comes, Lordship, is that there are various judgments even by this Honourable Court as well as by Shillong bench of Guwahati High Court, that a person who can challenge the Nokmaship has to be from the direct lineage of the family of the Nokma. It cannot be any outsider from the clan coming and saying that we have a. The Nokmaship is. Nokmaship, Lordship, how it goes in by inheritance. The mother chooses one of the daughter who is called the Nokna,
So,
and that is how it
somebody,
is devolved.
a person who is not from that line cannot come and claim.
No, it is not from the clan. It has to be a direct blood relation with the Nokna.
That is what.
Judgments are very clear.
Somebody who is not from that line.
That line, yes, blood, yes, from the lineage.
So
yes.
that is.
It's not that
is
any member
okay.
from the clan.
So a person being a Mahari will not have any
Yes,
claim. to
it's
it.
not that any person from the clan will come and say that we have some
Claim, yes.
claim.
Just show us which way you can seek appointment in this thing.
And even
So
in
now,
the,
according to you, who should be just? It's all okay. Just we got the primary thing. Let him address the court.
Lordship,
Now
but
see,
then
since
another.
the question of locus has come, What is your prayer in the writ petition? Let us see.
To set aside the order registering respondent number 4 and 5 as Nokma, Your Lordship. And further, an appeal has been filed, Your Lordship.
Just a minute.
Prayers at page 11, Your Lordship.
Just a minute. 1 second, hold on.
Gotcha.
Yes.
Lordship, the Aking is not the property of. Lordship, we are saying the Aking is not the property of the Nokma. It is the property of the clan, Your Lordship. The
That's
Nokma
all
is.
right. You see, that is no push to these things. Just to show that you have a rightful claim to be appointed in that position. That is what it is.
Lordship, in this Jensang customary practice, Lordship, if you see at chapter 9, Lordship, in this book,
Supply
Lordship.
is a copy. Have you given a book, a list of books?
No, Your Lordship.
Then how do you stand up to argue a matter? Now, who were the party in that thing? You were a party in that revenue appeal, in the revenue matters before the district council.
Revenue appeal, yes, Your Lordship.
You were the party there.
Yes, Your Lordship. We are the one who filed the appeal, Your Lordship.
The initial.
If I can just inject, my lord, and apprise this honorable court, the two prayer that my learned friend has made in the petition is the order of the EM and CM to set aside. And it is not the case of the petitioner, my lord, that in place of this person, with the private person, my lord, that he or his clan member should be accommodated as in Nokma. Now, who is the person, the private person who has been appointed? She is the lone daughter of the last recorded Nokma. Now, my lord, there are a number of orders by which, my lord, they was directed to file an affidavit that
That's
whether...
all right. We have taken notice. Mr. Deb has pointed out.
That is
Yes,
what...
man, it's all right. It's all right. You see.
No, I'm just pointing out, if you have no blood relation with the Nokma, you have no claim whatsoever. And who is he, my lord? He is he, my lord. He is not a lady that, no, I am the sister, I am the cousin, I am the daughter of the last recorded Nokma, so I have a claim. A man cannot be a Nokma, my lord, until unless he married the Nokma. A lady is the Nokma. By virtue of getting married with the lady Nokma, you enjoy the office of the Nokma as a male Nokma. Now, there is no such pleading in the petition, my lord.
Yes, yes. He is also not laying his.
He is not claiming. So, now can he come and seek a direction to set aside this order, appointment of a third party, and just to leave the Aking vacant, my lord? As per the Garo customary law, my lord, there is no Aking without a Nokma, and there is no Nokma without an Aking.
Yes.
This is a settled law. And there is a judgment of this honorable court, division bench,
Yes.
which empowered the last recorded Nokma to appoint her successor, my lord. And Mr. Paul was a party to it. Chalis Sangma, judgment is.
He was a counsel, he was not a party.
No, he was a counsel, my lord. On the same pretext, my lord, he has also filed, whereas the division bench has rejected his claim.
Yeah, that is all right. The thing is that,
But Lordship,
according to him,
My lord.
see, just tell us, Mr. Karim, according to you, who should be the rightful person for the position of Nokma?
Lordship, we are saying before registration of any person of Nokoma, the Charas and the Maharis of the clan should be consulted, Your Lordship. And Lordship didn't.
Now, your case here before is this, that the person who is holding the office of Nokma has not been appointed after consulting you, isn't it?
Yes, Your Lordship.
Now, according to you,
And
who should
Lordship,
be rightful person?
No, I'm not saying that, Lordship. Lordship, the principle laid down in Dure Sama also, Lordship has not been followed. Because as per Dure Sama,
You just show us some law that where is that? Or before that, you just take us to the orders passed by the EM and the CEM.
Order passed by the EM will be Annexure 1, Your Lordship, page 14. Type copy is at page 18.
Yes.
Lordship, if you come to next page, page 19, Your Lordship, Annexure 2, we have filed our objection, Your Lordship.
Just a minute. Let us first see page 18. What is this? Is the order, isn't it? Under challenge.
Yes, Your Lordship.
12A to zone 15. Yes. Yes.
Then, Your Lordship, at page 19, Your Lordship. Annexure 2, we have filed an application, Your Lordship, objecting to the decision of Respondent 4 and 5 as Nakama, Your Lordship.
Did not follow. What did you say?
Lordship, at page 19, Annexure 2, Your Lordship, we have filed an application objecting the registration of Respondent.
Just a minute. Just let us first see what is the contents of the order of Annexure 1. Mr. Day, you sit down, please. Just where you stand. So you are not reading this order dated 12 2015?
Lordship.
12 2015, you do not want to read it out?
Lordship, seen the petition filed by Shri Silasan.
Who is Silasan Marak?
He is the Chirag. He is the uncle of
He is the party here. He is the party here.
No.
He has not been appointed as Nakwa.
No, he's a Chirag. He's an uncle. He's a mama.
Mama of the brother of the last recorded Nokma, who is to give the proposal.
But this is for registration of Aking.
Aking Nokma.
Registration of Koknal Aking. This page 18 is not the original order. This is a typed copy.
Only thing, my lord, before my lord goes into all this disputed question of facts, if my lord just peruse this judgment of the division bench, who is binding on my lord, if I can say.
Yes.
If my lord may kindly go to para 14, because it is the case where the mother has appointed the daughter. Now, whether they have the right to appoint or not, that has been discussed in this matter, my lord. Para 14, my lord. In the present writ proceeding, keeping in view of our above observation regarding the Garo customary law, we have accepted the submission of the learned counsel appearing for the parties that the Garo follows matrimonial system of inheritance of the property, and when the woman dies and survived by her Nokna, the property vested in Nokna, who is not compulsory the youngest youngest daughter, and the Nokna is the favorite daughter among the daughters chosen by the parents during their lifetime to inherit the property. Now, if that is the case, my lord, the mother was still alive. The mother and the father were still alive, my lord, when the Nokna was decided.
Just please complete the reading, I think.
In the present case, it is a different facts now. In the present case, there is no material evidence or assertion of the parties that the Neme Sangma Michik and her husband so and so had chosen one of their daughters among the 3 daughters as Nokna. Here is the case, my lord, is a different facts where the father and mother has not appointed.
Now, whether Aking is a property
of the Maharis. Now, the Aking belongs to a particular clan, my lord. It doesn't mean the entire clan. Now, for example, my lord, if I am A Sangma, Agadok Sangma. No, just
wait, hold on, just let him complete. Let him complete his argument.
Lordship, if we read the judgment, Lordship, if we further read the judgment supplied by my senior Lordship, next line is Nokama may be the one selected by the Charas of deceased wife and Maharis, your Lordship. In the present case, it's clear from the order of the Deputy Commissioner, your Lordship, that Maharis and Chara had no objection to entry of Russian. Here, the Maharis and Charas, they have no objection, your Lordship. Whereas in the present case, your Lordship, we have objection, your Lordship.
And no, present case is a fast thing. There is no objection from anybody. At page 18,
no, your
there is
Lordship,
no
we are contesting, your Lordship, the registration. We are objecting the registration of respondent 4 and 5, your Lordship, as Nokama, your Lordship. To that effect, we have filed an application before the District Council, your Lordship. Lordship, in ILR 11 Assam 3 of the then Guwahati High Court, Shillong Bench, your Lordship. In that judgment, it says, your Lordship, when the succession of Nokama is contested, your Lordship, the accepted custom for selection is by vote of the Charas and the Maharis, your Lordship. Lordship, I'm sorry, your Lordship, I could not been able to produce this judgment today.
If you are objecting, if you say that you have objection, why you objection and whom do you want to be appointed there? Without you having any choice, any other person, why should you object?
Your Lordship,
your objection must have some basis. You just cannot come say I have objection just to disturb the entire function. Then?
Lordship, we are saying, because your Lordship, we are not, the Charas and the Maharis have not been consulted, your Lordship. And moreover, the principle laid down in Dore Sangma has not been followed,
You are
your
not
Lordship.
consulted, you have objection, that is why. Just say why you have objection. Or which way your consultation will bring a change in the decision. That means you must have somebody of your choice to bring objection. The objection just cannot be for the purpose of raising objection.
No, your Lordship.
Tell us what is your ground of objection and who should be, according to you, suitable person to be appointed in this office.
Lordship, because without consulting to the Charas and Maharis, your Lordship, we need to.
See, this decision has been taken without consulting you. Somebody has been selected. Now you are objecting to it.
Lordship,
and your sole ground, your objection is that you have not been consulted.
No, your Lordship.
Now let us assume that, let us just tell us if you are consulted, which way there will be a change.
No, Lordship, because the way the registration has been done, your Lordship, the principle laid down in Dore Sangma has not been followed, your Lordship.
You see, you would not like to follow something which just becomes a matter of empty formula. Now you say your objection, you have objection because you are not consulted. What is the point of your objection? What do you say? Do you say that this person is not suitable to the position? And if you say he is not suitable, then who is suitable? Just tell us.
No, Lordship, because if we see at the principle laid down in Dure Sama, Lordship, notice has to be issued, issues has to be framed, Lordship. But that has not been done.
See, where? In which case? Now, right now, we are basically on your locus standi. Once you satisfy the point of locus standi, then we'll go to the other aspect. Whether Dore Sangha has been followed or not, that we'll see once you prove your locus standi.
Lordship, as per the customary practice, Your Lordship, the Maria Charas of the client, Lordship, should be consulted, Your Lordship.
You are saying it again and again, assuming that you have not been consulted. And now, if you given your opportunity to, you see that you should be consulted. Now, what would be your opinion? What you will say? Tell us. That is why the court is asking you repeatedly that which way your objection or consultants will bring about a change in the decision. What happened after you filed the objection? What is the ground you have taken in the objection, page 19? Yes, please read it out.
The most genuine ground of objection.
Beat loud. This is court is old man, cannot hear it properly. Just say.
The most genuine ground for objection or complaint of the Mahari's clan, Kukunala King, is the illegal transfer and secret registration by unauthorized means and without the prior permission of the Kukunal Maharis of the Kukunala King. The then King Nokumashri Balsinat Mumin, who was illegally and without the knowledge and consent of the Kukunala King, Mahari, to which clan the Kukunala King belongs, has secretly transferred the King Nokumaship of the Kukunala King to the name of his son-in-law, Shisarit M. Sangma, and his wife, Smiti Sisapin M. Memara, the daughter of the Nokuma Malsinat Mumin, and as if the Kukunala King was his personal patala.
You have not followed it. What is the meaning of this objection? Yes. Then what happened after you filed the objection?
Lordship, after we filed the objection,
What is the date of your objection? 6th October 2015. Yes. Then what happened?
Lordship, after we filed the objection, nothing has come forward with your Lordship. So we have preferred an appeal, your Lordship,
Appeal against what?
against the order of the EM, your Lordship. That will be annexed to 3
So
at page
this your
21.
objection was not acted upon. It was not considered.
No, your Lordship.
Yes.
So we have preferred an appeal, your Lordship, for the CEM, your Lordship.
Page 21.
21, your Lordship. Lordship, if I may take your Lordship to paragraph 5 of the appeal, your Lordship. Paragraph 5 of the appeal, your Lordship.
Paragraph
Page
10.
22. 5. Page 22, your Lordship.
Page 22, para 5.
Lordship,
Yes.
that the former Aking Nokma, respondent number 3, Shiba Senat G Movement of Koknal Aking, had illegally and in total opposition of the Garo customary and usage had transferred the Koknal Aking to the family members with the respondent above name, who is the own son-in-law of the former Aking Nokma, and Srimati Sisabin Kemarak, who is his own daughter, as if the Koknal Aking is private landed property of his family. And that too was done without issuing any notice to the concerned Maharis of the Aking.
How many Maharis are there?
Lordship,
How many Maharis are there?
basically, Lordship, the uncles and the elders of the clans, your Lordship.
So how many? So far as your case is concerned, you said this notice was not issued to Maharis. So how many petitioners are there? How many?
Three appellants, your Lordship.
3 appellants. So 3 Maharis are here. And apart from you 3, how many are there?
Lordship,
If you say Maharis means what?
is the elders and the uncles of the.
Yes. So which way we say how many Maharis are there? Say supposing in a case, let us assume that there are 10 Maharis. Okay. And 2 Maharis are left out in the decision taking process. What bearing it will have?
Because here we are saying the Aking is not the property of the.
Just
so
lift the mic.
entire-
You
entire
lift
clan-
the mic a bit. Yes.
Because here we are saying the Aking is not the property of the Nokma. It's of the clan. So the entire clan has to be consulted.
You are not answering the query of the court. We are saying the court is asking you, supposing in a case there are 10 Maharis and 8 are consulted, 2 are not consulted, then what happens? What is the consequence of that?
Lordship, all the Mahari has to be consulted, your Lordship.
What is the consequence if not consulted? You are saying that we understand that. But then what happens? Because majority are consulted.
Lordship, I'm a little bit unprepared, Lordship, today. Lordship,
After giving so much of time, why should you take this thing? No, there is a case we can understand that 3 Maharis are there. Your case is that you have not been consulted.
Yes, your Lordship.
As per the custom.
As to the number of Maharis,
So
your
you do
Lordship,
not say that which way the consultation with you would have changed the decision of this. Neither you are not laying a claim on the off post, saying that somebody else is qualified. Now we do not know nature of your objection. Then why should we allow you to these things? Object, because we'll say that your objection has no bearing. It is not your case that all the Maharis are not consulted. It is not your case that all the Maharis are not consulted. At least this order dated 12/2015 says that there is no objection.
Lordship, with regards to the number of Mahari, your Lordship, I may be allowed to seek instruction, your Lordship, on that.
See, the thing is that the view which was taken by this court right from the initial stage is that you have no blood relation. That is why this court asked you to file an affidavit.
Acha.
Now you have not done it in spite of taking time. So that is where the prima facie, you see, the very thing, say like there is a presumption that you have no locus standi in the case. So until and unless you can show us something, all your arguments which you are raising, this is just for the sake of raising argument. It's nothing. Now, if you set aside now this order, then what happens to the position of Nakma?
Lordship,
Let us assume that we allow your prayer. Then what happens?
Lordship, then the district council have to
Take over.
no, Your Lordship.
We'll appoint an administrator.
Lordship, then the principle of Trisangma has to be followed, Your Lordship. Then the principle for the
You speak so low, you see, like raise your voice and then say.
then Your Lordship, if the matter is sent back, Your Lordship, we are saying if the matter is sent back, Your Lordship.
No. Send back means we have to set aside the order, isn't it?
Yes, Your Lordship. Lordship, then
Once we set aside, then what happens to the office of the Nakma?
it will go back to the original Nakama, Your Lordship.
The mother. No, it was the mother.
No, but then who are you to advance the case of the original mother?
No, Your Lordship, we are saying
The original Nakma is number 5.
Sorry, I responded 4.
Or respondent number 4. So,
Oh, sorry, I'm sorry, 6.
okay, whoever it is the respondent. So, you are advancing a case for respondent number 6. We will record it.
Lordship may give me
When there is a dispute of Nakma. Here there is no dispute. He simply comes and says that he has not been.
No, see, he is advancing the case of respondent number 6. That is what he is saying. So, what remains then?
The same case only that after my Nakma,
My
I
lord,
give it to my daughter.
Two things, my lord, which I want to point out is this. My lord, the petition which was filed by them raising the objection of the appointment of the private respondent was subsequent to the appointment of the private respondent. An application was filed. That cannot be decided because in quasi-judicial proceeding, my lord, review, my lord, there is hardly any chance of reviewing the order, my lord. So they have gone for an appeal. The order of the appeal is very interesting, my lord. If my lord may kindly produce page.
But then why you are going into all those things? See, there are two aspects.
Only thing, what has fallen from my lord, that they have no locus, my lord. That was one of the ground for dismissal of his appeal, my lord. My lord may kindly come to page 34, my lord.
Page?
34, my lord.
Oh, we'll continue in the second half, Mr. In the second half.
Lordship,
Come back in the second.
Lordship, may please, Your Lordship.
Yes.
Lordship, if another date may be given, Your Lordship, I'll come a little prepared, Your Lordship. Lordship, if accommodation may be given, Your Lordship, I will come more prepared, Your Lordship, so I'll be able to assist.
See, you have given so much of time. You want respondent number 6 be appointed. How can we allow you? The accommodation also becomes useless.
No, Your Lordship, we are not saying we want respondent 6 to be appointed, Your Lordship.
That is what you said just now.
Yes.
No, Your Lordship.
You cannot just, say something, stand up in High Court, say something and then you change it.
No, Your Lordship, we are simply saying, Your Lordship, the registration of the private respondents, Your Lordship, who is the daughter of respondent number 6, Your Lordship, has been done.
So that is all right. They have exercised their discretion. Somebody has
The
been
background of the
appointed.
case is this, my lord. BSF want to acquire some land. BSF want to acquire some land.
So there is some.
That is the background of the case, my lord. And that is a matter of record also.
Okay, we'll see to it. Yes. He wants accommodation. Shall we?
I have no objection, my lord. My lord, may accommodation.
Yes. When do you want?
After 2 weeks, Your Lordship.
2 weeks may not be feasible, my lord. They are keep on taking
Next
time.
week, Your Lordship.
And the entire acquisition process is
We
stopped.
do not know after 1 week also what will be the condition of the board here. Not possible.
My lord. No quarrel with that.
Just one, Mr. Skari Hart, the Learned Counsel of the parties. Stop. Mr. Karim, Learned Counsel, acting as the petitioner. 6 grant of some more time. Further preparation in the matter. The prayer has not been objected to by the Learned Counsel appearing for the respondents. Prayer allowed. List after 2 weeks. Yes. Be come prepared. You see, there is no use of pursuing a case where you apparently has no.
Lordship, I tender my
And
sincere
that
apology.
orders, prior orders, whereby court had asked you specifically to file an affidavit. You have not done. So now things are against you. Yes.
Senior Lordship enters this one. But number 5, Mr.
Yes.
Chandra is on the other side.
Okay.
It can be some other time, madam. Up to 2 weeks.
Come after 4 weeks then, madam. Come after 4 weeks.
4 weeks. So we'll say then on the joint request of the parties.
Madam.
This item 5 on the joint request made by the parties, list after 4 weeks. Yes.
Obliged.
Yes, Mr.
The number 8 is also left in the list. I don't know.
No objection, Your Lordship.
When do you want it?
Anytime, madam. After 2 weeks or 3 weeks.
After 2 weeks. This will go. Next week there is no slot probably. Okay. This is also just say as requested by the parties, list after 2 weeks. 8.
Yes, Lordship.
Yeah, please, Lordship. Item number 16, Lordship.
Yes.
This matter take up after 1 week, Lordship.
After 1 week there will be difficulty, Mr. This will go after 2 weeks. You are for the appellant?
Yes, Lordship. I am for the appellant.
Put up one application raising the issue of juvenility, Lordship. Because on the earlier occasion, my lord have, because while sitting in a DB, has passed.
You got the.
I got the judgment, Lordship.
But then we'll have it then after.
Yes.
After 2 weeks. 16. After 2 weeks. After 2. Yes. At the request made on behalf of the appellant, list after 2 weeks. Yes.
My lord, similar prayer in item number 17, Lordship. I am for the state here.
Mr. Sharma is there, eh?
Yes, Lordship. Yes, my lord. So that also after 2 weeks, Lordship.
I have no objection. Also on request made on behalf of the state respondent, not objected to by Mr. Sharma, learned LAD you just said.
LAC.
Yes.
Deeply obliged.
Yes.
Lordship, item 20, and bring some accommodation.
Item 20.
20.
Lordship, a short date may be given, Lordship. The matter is part heard, Lordship.
Mr. Deb, see, there are many matters which are part heard. But
Lordship.
the problem is that next week may be a problem, you see. So
Lordship.
it will come up thereafter.
Lordship, if it's possible on 8 July, Lordship. If it's possible, Lordship.
We do not know. You see, we have to see that. We do not know about the thing. If not next week, give him after 10 days or something. Just see a date and just accommodate him if possible. Will be possible next week. This is a criminal appeal. That is a problem, Mr. Dev. Because this bench has to sit in division bench also 3 days in a week. So that is what. We'll just see after 2 weeks then.
Alright.
We can just say in prayer meet on behalf of the respondent. Not objected to by Mr. B. Dev. Not that consider the pay on the appellant. List after 2 weeks. Yes.
I'll oblige.
Any other matter which parties are ready? Item 7. Item 7, you are ready. Item 7, who is the other side?
I'm for the respondent and he's here.
Who is the petitioner?
You are ready.
Yes, you are ready?
Lordship.
Okay, we'll come back after second. Come into the second.
7.
Your Lordship, this is the second round of litigation, Your Lordship. Your Lordship, this matter, in this second round, we are challenging the disconnection notice which was issued by the respondent, Your Lordship. Your Lordship, from in the first round of litigation, there has been a dispute with regard to the electricity bills. Then after that, Your Lordship, the matter went for to Lok Adalat, and after that, Your Lordship, the Lok Adalat has settled that there will be settlement between the parties, and that they will be meeting between. They'll be having meetings to settle the amount, disputed amount. Your Lordship, I'll take you straight away to the Lok Adalat order, page 190 and extra 17. Page 190. Your Lordship, this is the award as passed by the Lok Adalat, Your Lordship. Your Lordship, may I read? The dispute between the parties having been referred for determination to the Lok Adalat and the parties having compromised settled the case matter, the following award is passed in terms of settlement. As per the order dated 3/9/2014 of the Honorable High Court, the amount of rupees 30,68,140 shall be paid in 2 installments. The first installment of rupees 15,34,070 rupees shall be paid by the writ petitioners, whereupon the electricity connection shall be restored immediately. The second installment of rupees 15,34,070 rupees shall be paid within 30 days from the date of restoration of connection, and the current bill shall also be paid within the due date, failing which disconnection will be done without any further notice. Now, Your Lordship, will come to the important point, that is point number 4. The formula of settlement of the outstanding areas shall be mutually worked out within 3 months from the date of payment of the second installment. After this, Your Lordship, both the parties have had meetings.
No, so what is the payment?
Your Lordship.
As referred to in paragraph 1.
Your Lordship, that has been paid.
So these are not outstanding areas.
These are outstanding areas.
Then what about this para 4? Para 4, then what? That
Your
this
Lordship,
para 4 pertains to which amount?
outstanding areas including of the delayed payment charges as well. And for that, Your Lordship, we are challenging the notice because we don't know whether the DPC is inclusive in the impugned notice or not, Your Lordship. The amount of 30,68,140 has been paid by us, Your Lordship.
That is okay. That refers to which amount? That is not outstanding amount.
It is, Your Lordship.
Then, if it is outstanding amount, then paragraph 4 refers to what? Another outstanding amount.
Your Lordship, because as according to the respondent prepared a statement for the month of October 2008 to 2013. During this period, Your Lordship, the amount has already reached 97 lakhs. And in 2014, Your Lordship, the outstanding amount is of 2.14 crores.
Okay, then what happened?
After payment of this first installment of 15 lakhs, Your Lordship, there has been restoration of the electricity. And then after that, we have paid another 15 lakhs. Then after that, Your Lordship, the outstanding areas, apart from this 30 lakhs which is being paid, is to be mutually worked out between the parties. Thereafter, Your Lord, there has been a series of meetings between the parties. And Your Lordship, if you could come to page 212, annexure 28. Two.
Yes.
Yes. 212A is the typed copy, Your Lordship. Shall I read, Your Lordship?
Yes.
Lordship. At the outset, the Chief Engineer MEPDCL Shillong welcomed the Director so-and-so and the MEPDCL office present. The Chief Engineer had then requested the Director of Kamakshi Ispat Private Limited to submit his proposed settlement plan for liquidation of the outstanding dues. The following points were discussed. MS Kamakshi Ispat Private Limited, Birnihat, proposed that for settlement of the dues, the outstanding due of 97,75,189 due in March 2013 as per his calculations is to be considered. He proposed to pay 5 lakhs only towards settlement of the above amount every month along with his current bill and requested a 60% DPC waive on his outstanding dues. The Chief Engineer Distribution stated clearly that the above proposal cannot be accepted as the outstanding dues of the consumer as per latest bill, that is Energy Bill of January 2020, is rupees 9 crores 23 lakhs 77,102.69 paisa only. He further informed MS Kamakshi Ispat Private Limited that the request for waiver of DPC may be considered only after full payment of outstanding dues.
What is DPC?
Delayed payment charges, Your Lordship. The Chief Engineer Distribution requested MS Kamakshi Ispat Private Limited to come up with a fresh proposal which will take into account the total amount of 9 crores 23 lakhs 77,102.69 paisa, and the said proposal is to be submitted on 6/3/2020. A meeting shall be held on 6/3/2020 at 11 a.m. in the office chamber of the Chief Engineer for submission and examination of the new proposal. Thereafter, Your Lordship, the petitioner appeared before the respondent. If you could come to page 238, Your Lordship, annexure 36. 238.
Yes.
Here, Your Lordship, we have stated our outstanding energy bills. And here, Your Lordship, the total as per January bill 2020, it's 9 crores 23 lakhs 77,102. And here, Your Lordship, the petitioner proposed to clear the outstanding bill in 36 equal installments. The next paragraph, Your Lordship, after the particulars of the outstanding bill, we would like to state that we have always intention to clear the bills regularly and settle the earlier dues as soon as possible. Looking at the market situation and present economic condition, we request and pray you as our outstanding bill amount due till January 2020 is rupees 2 crores 42 lakhs 30,237, which can be collected in 36 equal installments from us, and DPC amount should be waived off looking the adverse condition of the industries. Here, Your Lordship, we are ready to pay the outstanding bill. And Your Lordship, if you look at the delayed payment charges,
That is a representation by you.
representation, Your Lordship, as per the last meeting, which was held on 4/3/2020. Thereafter, Your Lordship, there's no reply to this representation filed by us. Then, Your Lordship, you'll come to the office order by passed by the Respondent Corporation at page 240, Your Lordship, Annexure 37.
Yes.
Here, Your Lordship, in this office order, they waived, this order is being passed for waiver of 100% of the DPC of the outstanding dues as on 29/2/2020. Your Lordship, our representation was on 6/3/2020, and the waiver of this 100% of DPC, it is effective only as on 29/2/2020. Anyone who has delayed payment charges as on this date, they'll be waived 100%. Thereafter, Your Lordship, the respondent, they implemented this one-time settlement scheme, which you'll find at page 241, Your Lordship. There's this
What is the date of your representation? You said this is.
date of representation, Your Lordship, is on 6/3/2020.
It's not visible at all.
There's a type copy, Your Lordship.
Page 238.
Sorry, Your Lordship, there's no type copy.
2020, okay.
But it's 6/3/2020, Your Lordship.
Okay. Yes.
Thereafter, Your Lordship, on 25th August.
Means by order dated 25th August, your prayer was allowed.
Your Lordship, there's no reply to our representation.
No, but then waiver of 100% DPC be allowed.
Will be allowed, Your Lordship.
So that is what. That
But Your
takes
Lordship,
care,
on
that
the
case
base.
that takes care of the prayer you made.
Your Lordship, but
Yeah.
there's no reply to our representation, so we don't know which amount to be paid, whether we'll pay in 36 installments, because in the representation we had
That
paid
is-
for.
See, which amount to be, you see, you know what amount to be paid, the basis of payment, that is what is another aspect. Okay, but then, okay, so far as your prayer for waiver, that was allowed then.
Your Lordship.
Yes.
Then thereafter, Your Lordship, after that, Your Lordship, on 4th November 2020, they implemented this one-time settlement scheme.
Page?
241, Annexure 38.
Yes.
Lordship, may I read?
Yes. The typed copy, 241A.
241A is the type copy, Your Lordship. To all heads of Department, Government of Meghalaya, subject implementation of the MEPDCL One-Time Settlement Scheme 2020. Ma'am, sir, I have the honor of informing you that the Meghalaya Power Distribution Corporation Limited has launched the MEPDCL One-Time Settlement Scheme 2020 for all categories of defaulting consumers, including government departments having outstanding dues of electricity bills as on 31/3/2020.
They are referring to the scheme. Where is that scheme? That scheme is that is 25th August. That is the scheme.
Your Lordship?
It refers to a scheme, isn't it?
It refers to a scheme, Your Lordship, but
Where is that scheme?
Your Lordship, this is just the letter which we have received.
See,
internal.
it refers to that MEPDCL one-time settlement scheme 2020.
Your Lordship.
Now, do they mean that page 240A is the scheme? This office order, is it the scheme?
This is a internal letter, Your Lordship.
But then this has
It's
this
to
has
all heads
this,
of
this is an
department.
office order.
Office order.
Yes. This is an office order.
Office order.
Yes. So, that scheme, the reference of that scheme, that page 241.
241.
What is that scheme? Is it something different from that 240?
No, Your Lordship. 240, it's only a waiver of DPC.
Yes.
In this office order, they introduced only 100% waiver of DPC.
Okay.
They never introduced the one-time settlement scheme in this office order.
Okay.
This one-time settlement, it was introduced at the next page, Your Lordship, next year 38, page 241.
Yes.
This is a letter from the Chairman and Managing Director of MPDCL to all heads of departments.
Yes.
I have the honor of informing you that the Meghalaya Power Distribution Corporation Limited has launched the MEPDCL One-Time Settlement Scheme 2020 for all categories of defaulting consumers, including government departments, having outstanding dues of electricity bills as on 31st March 2020. The OTS scheme offers waiver of 100% of DPC or 30% of total outstanding dues, whichever is more beneficial to the consumer. It is pertinent to mention that as on 31st March 2020, MPDCL is yet to recover nearly Rs 700 crores for all the previous years. It is expected that with the implementation of the above scheme, the defaulting consumers, including consumers who have not received bills for a long time, will be able to settle their outstanding dues, which will improve the liquidity of the corporation for ensuring supply of uninterrupted power in the coming days. It is requested to extend your kind cooperation for wider circulation publicity about the scheme through office notice boards and
give up. Then what happened thereafter?
then thereafter, Your Lordship, they came with the impugn notice. Presentation, Your Lordship.
Where is the impugn notice?
Impugn notice is at page 242, annexure 39. Type copy is 242A, Your Lordship. Your Lordship, in this,
The rate has been shown there
Your Lordship,
in the impugned
rates
notice.
have been shown there, Your Lordship.
Yes. So now the amount which has been reflected there,
Yes, Your Lordship.
was it not calculated after applying all the
It's
benefits?
not calculated. We don't know, Your Lordship, whether they have deducted as per the office order and the internal letter between the departments. They just came up with this disconnection notice and they disconnected, Your Lordship, our electricity. There's no clear explanation of this is your amount, this much has been waived. This is your DPC, this much has been waived.
Now it is reference to a letter of the MEPD sale dated 31/1/2020. What is the 31/1/2020?
We don't have any knowledge, Your Lordship, about this reference because
So
it's not.
you have never tried to get it also? Was it not your duty to get it? Once it had a reference.
Your Lordship, the main issue here is that even after passing the order of 100% waiving of DPC and the office internal
That is,
letter
see, once
communication.
the one that has been done, you should have paid the remaining amount. Why you did not do that?
Your Lordship, here because we don't know how much has been waived. Because the outstanding
no, but then
bills also.
calculation is provided there in your own representation.
That is provided, Your Lordship.
Then?
After the office order of waiving 100% DPC and the internal communication between the departments of 30% waiver of outstanding dues is not mentioned here, Your Lordship.
Then show us what is that letter of the reference in the 30, that is 31/1/2020. Now that would be of some relevance then.
Your Lordship, we
Now
did
your
not.
entire grievance is that there is no personal communication to you.
Your Lordship. Even
Otherwise-
after filing.
Otherwise, it appears that whatever you wanted, they granted you that relief.
So, Your Lordship, that cannot be the case.
It appears that you have made some payment in November also.
We have made some payment, Your Lordship. Your Lordship, the only issue here is that in this impugned notice, we don't know how much has been waived, how much is our outstanding dues as per our last representation, which was for March. And this impugned notice, it came on December, Your Lordship.
What is that order date? That is letter dated 31/1/2020. That memo which is reflected there. Is this connection notice has been passed in reference
In
to
reference to this letter, Your Lordship.
that? Yes.
But Your Lordship, we never received any letter from them on the, especially on
But
our.
that should have been basis. You should try some. See, do not expect that they will sit at home and they will come and deliver you everything. If you are aggrieved by certain thing, that becomes your duty.
Your Lordship, the respondent may assist.
Have you tried
the
to get a
matter.
copy of this?
No, Your Lordship.
Then? Now, according to you, what should be the amount?
Your Lordship, we don't know. That is the issue,
No,
Your Lordship.
it's all right. But then say, supposing since you had filed a representation, and in that representation you have given a calculation that you will pay the bill.
We'll pay the bills, Your Lordship.
You see, that means that is 2,42,30,000 to 37, isn't it? After deduction of that DPC charge.
Now, out of this 2 crores, Your Lordship, in span of few months, the amount has come up to 9 crores. 9 crores, Your Lordship.
That is all right, but then how can we go into all those things and determine that? It seems okay, something, some abnormality is there. You see, like there is some missing link so far as this entire episode is concerned. Now, pursuant to your representation, there is an office order waiving 100%
100%
DPC.
DPC.
Now, 100% DPC that means that takes care of that amount of 6 lakhs which you have mentioned in your
6
representation,
crores, Your Lordship.
isn't it?
Your
If
Lordship.
you have to go by that.
Your Lordship.
But then again, further it appears that there is a scheme,
Scheme
one-time settlement scheme, isn't it?
Your Lordship.
Now, where is that scheme?
Your Lordship, this is an internal letter between the companies.
Where is that scheme, about the scheme? And whether that scheme was meant for you or it was only for the government department.
Your Lordship, here it's written for all categories of defaulting consumers, including government departments, Your Lordship.
Where it is?
Your Lordship, if you come to page 41, the
Yes,
first
yes,
paragraph.
Yes.
Defaulting
So that means-
consumers, including government
So there
departments.
is an assumption and it was for also.
All, Your Lordship.
Now, what was required upon them, the consequent to the passing of this order dated 25th August 2020 and that scheme of 4th November 2020, they should have calculated, made a fresh calculation.
Made a fresh calculation.
And thereafter should have made the demand.
Your Lordship.
That is your case.
And Your Lordship, there should be, since they have said that there will be waiver, and if the one-time settlement scheme is introduced, they should have come to us, pay this much amount.
That is what?
But for that, Your Lordship, the respondent
court
did
is
not.
telling you. Court is basically saying that after the implementation of the scheme, there should have been a reassessment of the entire amount.
Your Lordship.
They should have come with the clear calculation. And according
And
to
an
you, that notice has been issued without showing any details
Your
on what
Lordship.
basis that amount is arrived.
It has come up to.
Now, it has a reference of a letter. Now, that
Letter.
is what we want to see. There might be something there. This is one aspect, and second aspect is that where is that one-time implementation scheme? What the scheme contains, that also we must see.
Your Lordship, if the respondents introduce this scheme, they would
Yes,
be
madam,
in a
you have
position
anything on those two things, those two issues? Yes, Mr. Pandey.
Yes, yes, my lords. My lords, as far as my lords, the case of the
You are
petitioner
not
is
audible.
concerned,
Increase your volume. You increase your volume.
my lords, am I audible, my lords, now?
Voice is very low. The problem is that
My lords, yes.
yes. Speak.
Yes, my lords. Is it better, my lords, now?
Carry on. Let us see how much we can follow.
My lords, yes, my lords. So, my lords, in this matter, what I can see, my lords, that the request has been made to this court in the, if your lordship sees the prayer of the petition, the request has been made for setting aside the disconnection notice and waiver of 100% of delayed payment charges. That is the prayer which has been made in this case. Now, Miloj, as far as the disconnection notice is concerned, there is a due of about 9 crore rupees on the petitioner. And the schemes which the Learned Counsel of the petitioner is talking about, my lords, the scheme required them to make an application if they
So
want
where
to
is the
go by
scheme?
that
See,
scheme.
where is the scheme? Where is the scheme? Just show
My
us
lord,
the
just
scheme.
sees the first.
And then just
There
tell
are
us
the
also
two
that
things
amount of
which
9
I
crore.
can gather.
One of 9 crore, on what basis you came to that amount?
Right, my lords. Just sees, my lords, the first office order of 25th August, or
Yes.
at page 240A,
Yes.
240 capital A.
Yes.
So, my lords, in this, it is the office order says in interest of the corporation and in consonance of office order dated 15th January 2007, the MEPDCL hereby arrives waiver of delay payment charges subject to the following conditions.
Yes.
1. Waiver of 100% of the DPC will be allowed in respect of the consumers paying 100% of their outstanding dues as on 29th of February 2020. So 100% of outstanding dues has to be
So
paid.
just tell us one
Second
thing.
says,
Just tell us one thing. This office order came on 25th August 2020. So how do you expect
right,
that
Manoj.
somebody would pay the 100% on 29/2
Well,
2020?
no, as on 29 to 2020. So whatever is the due as on that date of 29 February 2020, you have to make the payment, outstanding dues, all the outstanding dues, and then you will be entitled to waiver of DPC. So that calculation has to be made. What is the due, and then that payment has to be made, and then you will be entitled to the waiver of 100% DPC. Second is
Just a minute.
waiver of
Just explain it properly.
yes,
Just may I
yes,
explain
Manoj.
it. Now it says waiver of 100% DPC will be allowed in respect of consumers paying 100% of their outstanding dues. Now,
Yes, Manoj.
say 100% of outstanding dues, would it mean that DPC is included there? And that
No, my
after
lords.
they
I
make the
don't.
payment, you refund it?
No, as per my understanding, my lords, DPC is getting waived. Apart from DPC, whatever is pending, current bills and other charges which are pending, you make the payment of that, 100% of it, as on 29th February
But then if you
2020,
introduce a
whatever it.
scheme on 25th August 2020, how do you expect that this condition would be applied?
No, it is, my lords, a back date. A back date of 29th February 2020 has been taken as a reference date. Calculations will be made up till that date. whatever is the outstanding due as on that date, you make the payment.
So if you see, since that waiver, your waiver came on 25th August 2020, then the outstanding amount on 29 to 2020 would mean the inclusion of DPC.
Milot, as per my understanding, it would DPC is getting 100% waived off. So there is no point of including DPC in the
Kindly try
outstanding
to
due.
understand. You say your condition is that the consumer paying 100% of his outstanding dues as on 29
Yes.
to 2020 would be entitled to 100% waiver of DPC. Is it correct?
Yes. Yes.
Now,
But
if that be the
outstanding due
thing,
will not include DPC. Outstanding due, because then there is no point of this waiver scheme. If outstanding due has to be included in the DPC, then there
that
is
is why
no.
this court is putting you question. That is why the court is having
But
difficulty
my
in
lord,
understanding.
this notification is not in question. The notification requires him in point number 3 to make an application. He did not make an application
That is
because
all
he
right,
was
but
not
then you
ready
should
to.
understand what this scheme is, what this order proposed to give, what benefit
Right, my lord.
wanted to give. Now, you say waiver of 100% DPC will be allowed in respect of consumer paying 100% of their outstanding dues on 29 to 2020.
Yes, my lord.
As on dues, as on. So that means the due
As on
amount
20.
as on 29 to 2020, if it is sought to be cleared in 100%, then
Then, my lords, they will
we
be
were
getting a benefit of 100% waiver. That is my reading, my lords,
okay.
of this document.
Okay, you are correct. Yes.
And my lord, there is a subsequent condition also
Now
that if you are
this
not in a.
outstanding amount
Yes, my lord. So if they are
was
not
to
in
be
a position
cleared.
to pay 100%
Okay.
of dues,
Okay.
then, my lords, there is a subsequent condition also that says waiver of 60% of the DPC will be allowed in respect of consumers desiring to pay their outstanding dues in installments.
Yes. And the third
So,
says that there has to be written request.
written request to a particular person, my lords,
So
that is
that was not done
assistant.
according to you.
Yes, my lord, that was not done. Admittedly,
Because
not done.
if
Their subsequent
if
representation
it
is
is not
also
done,
there.
the question of conferment of benefit would not come, isn't it?
Yes, my lords. Yes, my lords.
Yes. What do you say about
So,
this? You
Your
have to.
Lordship, in this regard, as per our last representation on 6/3/2020, Your Lordship, which we have stated that our outstanding bill is so and so, DPC is so and so. Your Lordship, they have not replied to this, so we don't know how much is our outstanding dues.
No, but then this office order came subsequent to it. So was it not your duty to file one application?
Your Lordship, for waiver of this, we have, for waiver of 100% of DPC, we have to pay 100% of our outstanding dues.
Minus
And
this. But then before you make the payment, one thing is that first you should file an application.
Your Lordship, because we have filed an application on 6/3/2020,
No, that is
they
before
never
that.
replied.
You cannot be considered an application after the introduction of this benefit. Otherwise, you have no lawful right to make a claim. See, your right to claim exemption or benefit is only on the basis of this thing. Just mere filing of representation will not entitle you to claim any benefit. Now, what you are trying, basically, you are trying to say now that your representation filed earlier should have been considered.
Not considered, Your Lordship, because this is our, as per our calculation of the dues. We don't know how much is their calculation, Your Lordship.
Whether this office order still holds, it still is in operation, Mr. Pandey? This 25th
no, my lords,
or whether
I,
basically it merges with your scheme, one-time settlement scheme.
yes, my lords. And my lords, the last line
Oh,
of
that
the
will
office
remain
order
valid
says
until
that.
31st October.
Yes, my lords. Yes, my
So
lords.
this has
Yes.
lapsed.
31st. Yes, it has lapsed.
Now remains the scheme.
Scheme. And the scheme also has now, my lords, gone because it was one-time settlement scheme. They did not even apply under the one-time settlement scheme.
This scheme is supposed to remain valid for how long?
My lords, just it has also elapsed. There is, my lords, a subsequent litigation also done by this very petitioner, which was disposed of by this honorable court, my lord.
Subsequent to this
So
writ petition?
Yes, my lords. They
That
did a
pertains to the
subsequent
issue
litigation.
involved here.
Yes, my lords. The current bills, as far as the current bills are concerned, they pursued another writ petition, which was, my lords, disposed of. Uh, that, my lords, that order, I don't think so is on record because that was subsequent to the filing
Yes,
of this matter.
but then those that was regarding current bill, isn't it? Not with regard to
It
the
was
past bill.
regarding current bill, and the petitioner was given an opportunity to make a representation. That representation was also disposed of, my lords.
Is it?
So that order may have some relevance in the sense that because of that there is some overlap as far as the outstanding pending dues are concerned. But both that matter was disposed of by this honorable court, my lords.
Where is that order? And what is the representation which was filed thereafter? Whether
That, my lords, I have the number
those
that
have
is
any relevance so
WPC
far as this matter is
530.
concerned? Now, madam, we will have to see this your reference of this thing.
Letter, Your Lordship.
Yes, that has to be
Your
seen.
Lordship, I'll take instructions with regard
That-
to this letter.
The secret has to be unrevealed before the court gets the fact. This is what is that thing? See, two things which this court would require to see is that one is that scheme, and other is this letter.
Reference letter.
And third, as Mr. Pandey said, of course, that you can. Yes, that order, and if they have filed in a subsequent representation to that, and your response to that representation, if it is relevant. Since Mr. Pandey is saying that might have some relevance.
Yes, my lords.
One thing is that, madam, we will not term your representation as a letter in response to that 25th August order. No question. See, here you are the benefit seeker. It is for you to go and approach. And since you have appended this order with the writ petition, you are in knowledge of that. We do not know why do you miss those kind of schemes and instead come and unnecessarily fight these litigations. Your relief were there. Dispute with regard to the claim, and even you see like waiver of that DPC amount. Honestly, this court may not. You see, until and unless the fact that something illegal has been done, but then it is if it is in accordance with rules, then there is no question of making any interference. Mr. Pandey, if there any scope of, you see, like giving them an opportunity to file a representation to you and reconsideration in terms of those scheme?
Because the only issue is that the DPC we are bound by the regulations framed by the MSERC, the Meghalaya State Electricity Commission.
No, that is
The
all right.
regulation, my lords, categorically in Rule 9 provides for charging of the DPC 2.5% on the outstanding dues, my lords. So that DPC is charged in accordance with law.
We can
And
understand,
there
but
were
then
multiple opportunities.
You have your authority to exempt that also, as you have done here by bringing in some scheme, isn't it?
Yes, my lords, that was there. Two opportunities, my lords, came in between, but probably the petitioner was not in good financial health as is revealed by his representation.
Then place us before the scheme and that order.
Yes, my lords. And as per my instructions, my lord, even I think petitioner is not operational. This company is not operational. It has stopped its operations as well. So there is
It's not in operation.
very less, as per my instructions, my lord, because the electricity has been disconnected. There is nothing. So it is the scope of any kind of settlement is also, my lord, minimal.
Okay. You are not operating anymore.
Lordship, it's for now. It has before it was a large-scale industry. Now they might have reduced their limit their production
But
as
then
well.
you are totally not ceased to operate. You are not totally ceased to operate. You are still in operation.
Your Lordship, I'll take instructions.
You see, unnecessary litigation, if if it is only with regard to the, you see, like adjustment of rate And if you have the real willingness to pay it, then it's all right. Otherwise, what is the question? Anyway, just hard learned counsel for the parties at some length. It appears just after considering the submission made by the learned counsel for the parties, it appears that what is that scheme says? There is no date, nothing, no reference. Okay, the production of
One-time settlement scheme. It is.
ME PDCL one-time settlement scheme of 2020. As reflected in the memo number CH page 241A. Memo number so and so, dated so and so, and this reference is to a letter. Is it a letter?
Your Lordship, it's an internal letter, Your Lordship.
In that page for 242,
242.
Is reference is to a letter, or it's an office order, or it's a what? Any and just a memo.
Well, that letter is also on record. 31/1/2020, which your lordship was
31/1/2020,
inquiring about.
where it is?
Well, that is at 234A.
Page
234, 234A.
Okay. Yes. This was sent to you, and that their scheme was introduced thereafter. Whatever this order of 25/8/2020, which remained operative till October, and that one-time settlement scheme, this all came thereafter. It seems you have not acted on the basis of this. Then what remains? Then you have no relief to claim. Whether a scheme is still in operation, Mr. Pandey? Any instruction?
No, my lords, as per my understanding, it is not in operation, my lords. It's a one-time settlement scheme, and
No,
subject to
that one-time
conditions.
settlement scheme was it was operative till what time?
Just a moment, I will.
And can we direct consideration of the petitioner's case under the scheme as one-time settlement? Is there any legal?
No, my lords, no, my lords, that scheme is over, and I have some background, my lords, of
That is
previous
we
cases which have
understand.
happened.
Can we pass a judicial order as a create a opportunity as a special consideration for the petitioner?
Because that, my lords, the petitioner doesn't, my lords, in this
You will
case,
not
this
agree
is
to
not
it,
the
but
fit
then is
case.
there any legal bar in it?
One-time settlement scheme, as per my understanding, is over, my lords. They have not put the entire scheme. That is the reason it is not getting
Just show us the
reflected.
scheme.
There
We'll
were
just see if
certain
it is not in
dates.
operation, then no problem. We place the scheme in that thing. Just what you say.
Yes, ma'am.
So it is necessary for proper adjudication of the matter. We'll give them one more opportunity to them. We'll just see. Let them.
Yes, my lord. Yes, my
The
lord.
learned counsel or the petitioner shall produced the same. They produce the aforesaid scheme. on the next date of hearing. When shall we have?
Your Lordship, after 2 weeks.
Yes, pray forward with the parties. List this matter after
Your Lordship,
2 weeks.
may I make a small prayer, Your Lordship?
Yes.
Your Lordship, even if the respondents are on hold of this one-time settlement scheme, Your Lordship, they can also produce, Your Lordship.
No, but then if you have, it is your duty. Just see, try, let us see.
Lordship.
See, if you are seeking some benefit, you should try to avail all the opportunities. You do not do that. Instead, come to court. See, this is this notice dated 31/1. It was there in the record, and you have argued your case without even knowing it. It is not that that opportunity was not given to you. And the non-consideration of representation also, how much help you in making out a case here? Even if you say that they have not considered. But then all those schemes came thereafter. You should have availed it. Okay, we'll see you on the next date.
Highly obliged.
Obliged.
Just keep this away. No other.